intellectual property that we'll look at. We already saw copyright and trademark. So after copyright and trademark, there's a third type that maybe you haven't heard of at all. That's patents. And patents, we'd probably say these days, are among the most valuable intellectual property. They were, for a long time, they were kind of trailing behind. But patent law is now the most valuable type of intellectual property. And patents, exactly what they are, they're compared to the other two. You might say, well, they probably shouldn't be the most valuable because they don't last very long. They have the shortest period of protection, like you see down there, the fourth point. Patents in Canada only have 20 years of protection. Right? We saw copyright was however long the person lives. Once the person dies, once the author dies who did the copyrighted work, you still got 50 years after that before the copyright lasts. And trademark goes on forever till the end of time, right? But patent only lasts for 20 years. And the reason why that's true has to do with what the goal of patent law is. The whole idea behind patents is actually wrapped up in the word itself. Patent, the word patent, actually means what is clear, what is obvious. If something is patently obvious, that's an adjective you'll hear often connected with obvious. And it's that in order to get a patent, you have to convince the patent office, and we have one in Canada. It's an office whose job is just to receive and record and register patents. You have to show them your design for something. You have to show them that you've come up with an idea not for some creative expression, not for some mark of craftsmanship like trademark, but for a design of some new thing that does something better than anything else that's done it, right? I mean, perhaps not necessarily better, but different. And the whole idea is that if you send the patent office your design, your explanation for how to make the thing and how to do the thing, the process or whatever it is that you want to protect through patent law, you're telling them, okay, once this 20 years is up, then the public, through the patent office, will have received all this important information. They'll know more. And so we figure we're paying people 20 years worth of exclusivity. For 20 years, only you have the right to this information, to produce this thing, to make this design. And in exchange for that, you're telling us how to make it so that when the 20 years goes by, we'll be able to do exactly what you've been doing for 20 years. So you've got 20 years worth of making money off your design. And at the end of those 20 years, we benefit in having all the information we would need. It's a deal between you and the state that you're giving them the information in exchange for the protection. If you don't claim a patent, if you decide, well, I don't want to tell them how to make whatever it is that I'm making, then until you claim that patent, anyone else can come along and make your invention as well, right? There may have been a few people who were kind of trying to figure out how to do whatever it is you did. And if somebody else, a couple of years after you, figures out how to do what you did, then as long as they get the patent registered first, as long as they get to the patent office first, then they'll be able to box you out to stop you from producing that thing. So it's definitely, you want to be the first one to get your patent registered. Now, in order for the state to give you a patent, they have to be convinced of three things. These three things, in order to qualify for a patent, is that your idea has to be new. It can't be just like, yeah, I've got a patent on this great thing. It's you put it on your foot, keeps your foot warm, it protects it from the weather and stuff, and it's called a shub. Yeah, I want a patent on shoobs. Only I can make shoobs. Right? They would say, well, that's not actually new, sir. We already have shoes out there, so we can't give you a patent just because you're pronouncing it slightly different. It also has to be something that's actually useful. If you come up with a new idea for something and it's brand new, but it's completely useless, the patent office can't give you a patent for it. And finally, it has to be something that's non-obvious, right? If the whole idea of patent law is to try and protect innovation, to encourage people to come up with new scientific explorations, then it can't just be something obvious. So it's got to be new, useful, and non-obvious. Those three things there in that third bullet point in order for you to get a patent for something. And it's, again, to encourage innovation by rewarding people with a period of exclusivity, but also in encouraging that innovation is to make sure that all the fruits of that innovation, all those new ideas, get to society when those 20 years are up. And the good news for you, if you have a patent, you can stop others from manufacturing your invention. You can get injunctions from the court to stop them from doing it. You can shut down whatever it is they're doing that you should be doing in order to get your money off it. In fact, there are court cases where if somebody successfully sues for infringing somebody's patent, they can get a lot of money as if they had started the company themselves. So let's say you come up with a brand new idea for a washing machine that is, not just a slight twinge on the existing thing. It's actually brand new and it's useful and it's non-obvious. And let's say somebody else doesn't want to respect your patent and starts ripping off your idea in their washing machine, then you can sue and force the court to force them to hand over the profits they made from ripping off your idea. So patent law can be very, very powerful. So we've seen copyright, we've seen trademark, we've seen patents. All three of those are formally protected under intellectual property law. There's another type of intellectual property that isn't. And in some ways, it can be, even though it's not actually property at all, it can be very, very, very valuable. So this fourth category, which is kind of a half category, is trade secrets. Now, trade secrets have value even if they're not actual formally protected intellectual property. The way that they get protected is generally through contract, generally through non-disclosure agreements, right? Like if you go to work for a company and you find out what it is about how they do whatever it is they do that makes them so successful, then maybe in order to work for them, for the privilege of working for them, you have to agree to sign an agreement that says you won't go to a competitor and tell all the secrets to them. Otherwise, you agree to pay a huge penalty, like maybe $2 or $3 million. Now, the example I'm showing here, and you guys know this one pretty well, is the Coca-Cola formula. The Coca-Cola formula has been protected as a trade secret for over a century now. And on the right, what you can see in that picture there is actually the formula for Coca-Cola on a piece of paper is in that vault, which sits in Atlanta on display, and I think it's called the World of Coca-Cola. But it's some public exhibit where if you're a big Coke fan, you can go there and see like old vintage Coke machines and stuff. But they have the actual trade secret on display there. It's apparently the only paper written version of it. Was first put in a vault back in the 1920s as a way to secure a loan. And since Coca-Cola hasn't patented their formula, they haven't copyrighted, there's no intellectual property in which Coca-Cola has claimed that they've actually guarded off their formula. Anyone who can emulate the Coca-Cola formula is allowed to do it. There's no legal means of saying, well, you're not allowed to imitate their taste perfectly. If you are listening to this right now and you figure out a way to perfectly imitate the taste of Coke, you're allowed to sell it and they can't sue you for it. Right? You wouldn't be able to call it Coke because that would be breaching their trademark, but you would be able to sell it because they don't have any intellectual property weapons to fight you on it. But if you were to go and work at Coca-Cola, find out what the formula is and get that trade secret, and then you were to either tell somebody about it who you shouldn't have, or you were to go to a competitor or start your own company and use their information, they could sue you for that, not on the basis of intellectual property law, but on the basis of the contract law, the promise you made to not do that specific thing. So trade secrets, on the one hand, very, very weak, but at the same time, they can be very, very powerful because as long as you keep things a secret and they stay a secret, then they don't run out like patent does or like copyright does. So those are our four categories: copyright, trademark, patents, and trade secrets. And the next thing we'll look at are cases where these different concepts run into each other or run into the law.